OKFM 101.7.
Lawyer Edudzi Tamakloe, my former president Mahama, private legal practitioner, and yenino ebetwetwe nkomo. Law, memwache.
Lawyer Kwame Chigeji, I'm a
It's a major so.
senior Obey.
Aha. I was it this fight.
And I meet here no problem. We said me senior Obey. Why am I? Who put the questions need to him? No, who said what corner no bar. Internet so one said he have a new question for himself. No answer new question. No, senior daddy watch.
Baba ko kan ye no ye. I think it
when we be on the nam cases now no obo nyina. Oh, no, or the by time, sad time no betchum.
Oh, Okotu, authorities like Abu Ramadan, Tufuo,
Abu Ramadan, Obesin called Tenadi, and Obesin called Kansi, and on the Namhunina. Nina no or the by time.
Oh, but to buttress a point anyway.
Oh, may say, no, be a very simple question. Be say. Article 2978. What does it mean in the context of this current conversation? When to me, and also for Article 296, 296. 296 has nothing to do with this conversation. What be say? Article 2978. In reference to this current conversation, what does he have to say? In fact, so Ukra Constitution.
Ukra Constitution.
But you call Article 295.
295, but okay.
2952.
2952. Now, men kind of had their own. 2952. Okay. I'll say 2952, but sorry.
Yes, sir.
But 2952. The watcher a woni. We kwade na atata so but never. 294 2952 but any or say but you have to me 2951 by interpretation by inquiry. That's 181 of the 2952. Where are you? But
295
and the 2 in was it in this constitution and any other law? A reference to a holder of an office by the term designating his office shall, unless the context otherwise requires, be construed as including a reference to a person for the time being lawfully acting in or performing the functions of that office.
Hold on. Into Oko Article 103 and 102. Article 102.
Article 102. You go ready air count Josue.
Article 102.
Okay. Then go yes I wanna walk out.
That be men penasa one kasa okaya na Ghana fu na tie.
Article 102 Pacho clause saying
no call 3 no near jadi.
Okay. Article 102 clause 3 or say 2 Mpajomboa. A quorum of parliament apart from the person presiding shall be 1/3 of all the members of parliament. What's it? Say parliament bet me a mama from quorum. Say we de what tie dwam free hwa. Wa modin e wa ha first speaker
Oti aje o se die oti dey
edwamu it is sebi manada suma so saponche kra na e ba ko fa no na adata no ono na oti dwamu a to aso but to aso what say shall be 1/3 of all members of parliament.
So o say apart from.
And now almost say it does not relate to any voting, but this is quorum.
No, tobo. Said the for me Kuroma Okotwaba.
Maybe.
A yes, step by step.
Mm-hmm.
A yes, step by step. You first form a quorum to do business. And I will say Obet Nejemwa, even if you a member of parliament, say, and ne Betna Jemwa, who read 102 together with Article 2952 now. What to me, and form a part of that quorum.
Mm-hmm. Mm-hmm.
Now, as I also say, under Article 2978, and then I will say, Miss Senior, quickly no Ujani visa constitutional provision.
Because at 2952, no say, in reference to a holder of an office by the term designating his office shall, unless the context otherwise required, be construed as including a reference to a person for that time being lawfully acting or in performing the functions of that office. Let's
Fantastic.
okay.
For the time being now, performing that function. No.
Next, 102 no bind you.
You read it together.
Because what can shall?
Sure.
Okay.
It was sure. Throughout the 29-page decision of the Supreme Court, no reference is made to Article 2952. No reference at all.
Maybe it was not relevant to the matter on the table.
How? Is it not a rule?
It's a rule. It's a
rule.
It's a rule.
Sebi. And this will be an acting CGR.
I know. Wouldn't other lawyers and so
Now, Black Kwame Sebio, in the 1992 Constitution, one who any rule defined for the Vice President.
There be a constitution. There is a lacuna. Says Owua. Sabinyami Enfa. There is that lacuna. Say Vice President in Owua. A quiet first way ye be no. Constitution is silent on that.
Oh no, and it is by appointment.
No one's what you be. But I guess the constitution is spelling out too.
Eventually, I'll go back to Parliament. Okay, Emra, Yapa Mills, a woo yeno. H. John Romani, yes, swear in. There was a lacuna created for the Vice President position. Okay.
Yes, sure.
So it was by appointment of Emisata in our core Parliament.
Okay.
So it is not much of a lacuna per se.
Oh, okay. Now, explicitly.
But you see, back to the substantive matter. Okay, you see, the basic principle of constitutional interpretation, and yet the principle that you must not interpret the Constitution in a manner that results in internal inconsistency. In Tosha, it has been stated again and again that in interpreting the Constitution, it must be interpreted as a whole.
Not in part.
Not, you don't hold one part. Now, my interpreting when Daddy, you have to interpret the entire Constitution as a whole to avoid internal inconsistency. Now, Sabio, wow, provisions here, and I've had cause to ask my friends, lawyers in the NPP, say, when a deputy speaker takes that position, is he not performing the function of the speaker? Say yes. And maybe some will say, we say speaker bit me out by reason of this judgment. And yes, sir. And I'm saying, first of all, the voting in the floor of Parliament doesn't just start with a division. It must first start with a voice vote. And yes, sir.
Sanity.
So you have a situation where the speaker or deputy speaker presiding were putting up the vote. Those who are in favor say, yeah, no answer can yeah.
OKFM.
Those who are in favor of no answer can no. Or you are not say the yes have it. How can that be? How?
And that is one more you know the one more day adwuma our parliament too.
But the Supreme Court said obey me to Abba. And you only vote when there is a division. And yes, sir.
Sure.
But the division just doesn't happen. It starts from a voice vote. Say, Obika say, anything I recently, me am seen in your market. I said no buy and also look, the yes have it, the no's have it. He's not convinced. So he called for a division. And
sure, he called for a division, yeah.
He called for a division. And that is when the issue of you coming to participate in a vote happens. Because they are not clear as to the nay and then the no. Now, you have a situation where you are saying that the deputy speaker presiding has a constitutional right to vote. And yes, sir. So if he has a constitutional right to partake in the vote only after a division, does he have a right to partake in the voice vote?
That is also another issue. So, we're going to vote today. He also has the right to partake in that.
So you see the absurdity I can.
No. Say, so nine.
No nipa na ono waka say no. Afi no so declare the outcome of the years.
Okay, so what better you say? Why, so as many as would do say I. No, I say me. I say I.
But
in consonance with them.
But they no have it.
Wow.
Is this not absurd? Manifest absurdity. And we always know, sir. And to be honest, the Supreme Court itself, from a reading of the judgment, admits that they use the literal interpretation.
Mm-hmm.
For a long time, the Supreme Court has always said, look, we are in the era of the modern purposive approach to interpretation. An interpretation that ensures that you are reading all the parts of the Constitution together to know why. The very reason why.
But
just 30 seconds.
Okay.
The reason why I need a person speaker and partaking in the vote, they say, we want a semblance of impartiality. What I say? We want a semblance of Aquana or presiding no. Obey what? Impartial to both sides.
But he has an interest too, because he represents a constituency.
No, but
in addition to say what presiding.
No, first of all, the election of deputy speakers and now the position of deputy speaker, it is not given by birthright. You put yourself up to be elected. You for sure be a major position, no. Anything I wish I know because Joe Wise the salary and yet the same thing as another MP.
Okay.
His salary is higher. The privileges as deputy speaker are better than all the other MP. So why wouldn't the other MP say nana yetu yeswaba?
But when see friend, apart from so presiding, will be a friend speaker.
No, but is the role.
Okay, the role.
2952. I see the role. Position now Ukrano. 2978. I see the role. Into the Yeka say Yeka be Biafra speaker one. It refers to his deputies as well. And not the mudu why you become silent over it.
Mami Musadia,
who do that portion there? No more you're silent over it.
Mami Musadia, as Justice of the Supreme Court. Justice Doche, Amagacha, Professor Kote, Owusu, Miss Lovelace Johnson, Honyenuga, and Kulendi. Enti, some provisions in the Constitution, that is 295 to 297H, you know. One man take key into cognizance of the fact say bibia as a common included in arriving at the decision on me and also be who say here
Abra Kwame, say I can phone a cow myself. Say the ultra sano.
when you say the chia.
So assembly it's not in reference to only one person. Anna
There be
sana reality. What I say? Sana, and that is why you see we are building a democracy. Mekai say na me senior Obi Bwahin and make reference to for an attorney general. Bisano. Proud to the decision into for an attorney general, a private citizen could not approach the Supreme Court.
Okay.
Without they asking you of your capacity. Into Okaya, into for an attorney general, no. And where Dr. Mwakutu for then lecturer at KNUST. Or the case in a buyer, the then attorney general, raise a preliminary legal objection. Say, now one Mwakutu Kokra, we a busybody. As I'm not for Apalu, within the Apalu.
Debbie.
I'm Akoni Apalu, they say. It will be a busybody, only capacity, confuse na koda. And now the court then has a Dabi in defense of the constitution, it is open to every Ghanaian.
okayfm.
And for that matter, Amwakutu has a community of interest with the constitution. Bisa said, was it in any black and white? Yaman Penin and Ado Dankwe Kufado, only Chachuchika in a year case. No. Bisana said, at that time, no, was there any black and white provision like that? When he decided to represent Dr. Mwakutu for, where did he draw the capacity for Mwakutu for? And yet that problem now, you in that constitution. And it now, when we're doing the 1992 constitution, we brought Article 2 in the constitution, empowering every citizen of Ghana or any person. Supreme Court, ACA, in MPP versus Attorney General, say the reference to any person includes even artificial persons. What I say? Because the constitution itself is organic. And yet, you give a construction that creates chaos. Sebi. In a long while, when the Supreme Court decision, Brakwame Abba are creating this level of public uproar. Now, one of the strange things, if you read the judgment, there was a portion that the Supreme Court says to you. The reason why they think a deputy speaker should have the opportunity to vote, TNEO, is that there can be instances of opportunistic absences by a speaker. What is the meaning of that? Bravo, what is the meaning of that? Opportunistic absences of the speaker. And so, if a speaker is opportunistic in his absences, then what it will mean is that at all times, the party where the first deputy or second deputy comes from will be disadvantaged. So it clearly tells you that this decision is to solve a present problem.
Okay. Now, Mami, Obia.
After the Supreme Court, not you, Miami Senior, and Parliament or court, Tenadi and everything to say the Constitution is supreme. And yes, sir, all the point he made was to establish supremacy lies in the Constitution. This is what he himself says in his submission today. Now look at him. Cleverly, he runs away from the fact that the same Supreme Court in this particular decision now says Parliament itself should go and look at how they will amend their standing orders to cater for this situation. Why didn't the Supreme Court go ahead to do it? Because the long and short of it all, at the end of the day, the Supreme Court came back to square one and said, Parliament, you go ahead and decide You go ahead and decide how you want this thing to be done. So what was it for?
Okay. Okay.
What was it for?
Yeah, okay.
Because you see, if at the end of the day, just 30 seconds, if at the end of the day, as the Supreme Court rightly pointed out, okay, we come back to the position where the Supreme Court is now telling us, go back. And let me just read that portion, page 23. Oh,
yes, me page 23.
Page 23 now, yeah, this.
Maybe page 23, yeah.
Or say, it must be emphasized, however.
But what kind page 23 session Benny?
Page 23, paragraph. Maybe I started. It must be emphasized.
Okay, what the time here?
Okay, so the main kind. It must be emphasized, however, that the procedural or operational rules to practicalize the protection of this constitutional right in a member presiding in the absence of a speaker and his or her duty to represent his or her constituents in the vote or decision are matters within the exclusive domain of Parliament itself.
Mm-hmm.
Are we not back to square one?
Mm-hmm. Now, 23 one raise your. For example, it could lead to opportunistic absences by a speaker or the one or the deputy speakers, as an absence would mean a vote lost by presiding member and their party.
Look at that.
So they took cognizance of these issues and in arriving at the decision.
So you can see, this whole decision is to cure the current challenge that MPP having in the current parliament. Let me say this. When the position of deputy speaker came about, the MPP offered Joe Wise. At that time, no, they didn't advert their mind to the position, say, per the 1992 Constitution, any time a vote or a motion is put and the vote is equal, it is deemed lost. Oh my God, now come with the Bema NDC so that they will retain all their 137, 136. Oh my God, it is later, Omu say, that's to pay true. Now and they say and they brave and they then empower. And that is what has brought all these challenges we are now having. It is just the numerical.
But I did page 24 of the ruling. Number 9, a comparative analysis.
Mm-hmm.
And what they compare amount of see the position of a Ghanaian constitution on the question of the right of the presiding officer of parliament, speaker or presiding member to vote on a matter in consonance with the law or practice in Commonwealth Anglo-American jurisdiction generally. Thus, in jurisdiction where, as in the case of Ghana, the speaker or the presiding officer is not a member of the legislative body, the general practice is that the speaker has no vote in matters before the House. For example, in Kenya, where Speaker of the National Assembly is not a member of the Assembly, but where deputy speakers are, the Constitution 2010 is categorical in Article 122 Clause 2A that the Speaker has no vote. Again, similar to provisions in the Ghanaian Constitution, the only other voting disqualification in Parliament per Article 123 of the Kenyan Constitution applies to a member who has a pecuniary interest in the matter to be voted upon. Therefore, unless disqualified by a pecuniary conflict of interest, a presiding deputy judge in Kenya is entitled to vote in legislative measures. Not just in Kenya,
because the Kenyan Constitution almost anticipated this problem.
Okay.
So they have cured it.
Mm-hmm.
You cannot use quote-unquote interpretation to rewrite the Constitution. You cannot, in the name of interpretation, rewrite the Constitution. If you do so, what you end up doing is to usurp the powers of the framers of the Constitution.
About Botswana, about UK.
Country, in all of those countries, they were forthright. Say A, B, C, D. Why? Recently, local assembly issue by then the Uncle Supreme Court or more interpreted, but we're thinking of a referendum.
OKFM.
Recently, on Mampini, yes, will be creating new regions. Then Young Country Supreme Court interpreted new one create additional. But we went for a referendum to that effect. Because the danger also, and this is what we must all guard against, is a situation where, in the name of interpretation, we'll basically be rewriting the Constitution. Yes, it's true. So the framers of the Constitution could not have anticipated everything happening. So if situations today warrant a certain thinking, we know what to do. Let's go back to the people and ask them, is this what you want?
Okay. Now, Loe, Maminu Yesi, Mr. Wadaruma. Now, Supreme Court the ruling number. Na say obia waye working kind documents bia say research work no ne ade ya na executive summary no na edin ebu no document ne kai but eno so kra ne dia na ya twetwato so that you see what's contained in the document. Now we no say wo fa a conclusion no my only 3 point our conclusion was it.
So the last time, Kasa, semi-true. Now we'll be the issue of contempt and all of this. Now I told you. And then the court is saying that Parliament itself should practicalize how this thing will be done. And yes, sir.
Aye, there's a more kwanya mo beva so amode be yaduma.
Exactly.
Na ye de ye ntimi nhamo.
Ye ntimi nhamo.
Ah. So brafo no sa na ase kire.
Yes, what ye ntimi nhamo. So find a way to practicalize it. Now, with this arrangement in Parliament, how are you going to even amend the standing orders?
And standing orders were promulgated in 2010.
No, this standing orders are almost 30 years. Almost 30 years. It is here now, Parliament should find a way to practicalize it. One side should say way, another side should say. So what are we going to do now? From the beginning, I told you something. That the kind of parliament I want is a parliament where the conversation should be about consensus building.
Okay.
But okay, somewhere we will be where we are today. You cannot think so. Oh yes, now I have a judgment of.
Eti bato ye ni biribi asese speaker amfadie apex court of the land no anya dwuma. Parliament can be cited for contempt or the speaker for that matter.
No, Senana Mama or say it must be emphasized, however, that the procedural operational rules to practicalize the protection of the constitutional right in a member presiding in the absence of a speaker.
Okay.
Is within the exclusive domain of Parliament itself.
And I guess some what is a consensus to be said.
So are we not back to square one?
Okay. Mate.
So we are back to square one.
Okay.
And then Portuguese and a friend of pirate victory. What are they? Ukra judgment, Ukra will turn by judgment, no mouse. Then, per this decision of the Supreme Court, who deputy speaker, which means Orianko Council of Swaba.
Okay.
Because it has not been operationalized yet. The procedure has not been operationalized yet. And
wow.
Okoye quarter, Sebu Okoye quarter. You were the FM constitutional instrument. So the procedure of how to litigate in Ghana is regulated by constitutional instrument. It was CI 47, CI 132, CI 19, all of those things. That one is set for the rules of court committee.
I see.
So even the court colleges
law
exclusive domain of Parliament. So this problem should not have been a Supreme Court matter.
Oh, okay. Matthias.
It should have been left for Parliament itself to find a way.
Now,
the man has a right to vote. Correct. What's a son I work out? Meanwhile, what say? So bet me you, so want me you, and it's a parliament in a soon decided.
So we are back to the
We are
root
back
again.
to square one.
Okay. Lord, me that's no pay.
That's in the back, Kwame.
Me that's making care mu kakra bibi na ebedi nko. Me that's okay. 101.7 lawyer Godwin Edudzi Tamakloe, private legal practitioner, aid my former president Mahama and any twiko. Mr.
OKFM 101.7.